Okay guys, so we'll just do a quick recap of what we did in the previous class. Yeah, we're coming back to our flowchart, that is we're looking at CPC. Our CPC is Civil Procedure Code of 1908, consists of both your substantive law as well as your procedural law. Your substantive law consists of sections 1 to 158 and your procedural law consists of orders and rules. Okay. So, generally when we look at, even in your textbook, you will come across many things where it's written O1, like O, order 5, say, not even rule, it will be written like this, or rule 9 or rule 10. Okay, these are nothing other than the correlated procedural provisions that you have to read along with that provision. Okay, so the CPC, excuse me, in your CPC we know that there exists someone known as a plaintiff and we have a defendant. Can there be more than one plaintiff or defendant? The answer is yes. They have to approach, the plaintiff is usually the person who approaches the court of law having the correct jurisdiction and within the proper period of limitation. So, limitation is governed by our Limitation Act that we've studied before. Our jurisdiction is what we had covered into from section 15 to section number 20. As is provided in your CPC. Apart from that, we have concepts like original jurisdiction, appellate jurisdiction, criminal jurisdiction, all of that we have. And then things like pecuniary, subject matter, personnel jurisdiction, things like this. Okay. Now, generally a plaintiff will approach the court of law and submit something known as a plaint. Okay. The plaint is a document which needs to have the facts, the cause of action, the law under which they are approaching, the evidence to support their claims, and most importantly the prayer. Now, this plaint has to be submitted in a court of law within the proper limitation and with court with correct jurisdiction. Then the court will send a summons to the defendant asking him to come before the court of law. Now, the summons can be sent in two ways. One is the court itself will serve it with the judicial officer, or the plaintiff himself can send it. But if the plaintiff is sending it, then he has to provide proof of service to the defendant. Now, the summons should be sent within a period of 30 days of plaint, and then the defendant has to turn up before the court of law again within a period of 30 to 90 days. And he has to submit something known as the written statement, which is what? An exact reply to the plaint. Apart from being an exact reply to the plaint, it can consist of set of counterclaim and evidence to support their claims. And obviously, that must also consist of the prayer. Now, once all these documents are submitted before the court will go ahead to form the issues. What are the issues? Whatever is asserted by the plaintiff and denied by the defendant becomes the issues. Who forms the issues? The court of law will only form it. Okay. Now, based on these issues only, we can say that the formal procedure of trial has started. And then comes your arguments plus all your counters. Then if any additional evidence has to be submitted, that evidence, your rebuttal of evidence, cross-examinations, everything will happen at the stage of trial. And then finally the court will end up giving a judgment. A judgment is nothing other than a statement relating to the rights and liabilities of parties. Okay. and based on this judgment, a decree will be given. Now, this decree can be of two types. It can be preliminary or a final decree. Normally, the final decree has to be based off the preliminary decree, but the preliminary decree has to be based off the judgment. In between this, there's something known as an execution proceedings, which can be entered into by the parties involved. Okay, so execution proceedings has to be applied for. It's not an automatic procedure. You have to apply for it, and then the court will grant the start of these proceedings. Did we do anything beyond this? One more thing we had done, I had explained. Sorry? Yeah, we'll come to that. Now, one more thing in between that we had studied is if you give a plaint, you get a decree. If you submit something known as a interim application, you will get an order. What is an order and a decree? They are the same. The only difference is an order is temporary in nature. When can an interim application be submitted? Anytime after the plaint is submitted to the court. Why do you submit an IA? To get some kind of immediate relief. Okay. So, this is what we had seen. Then we had come down to the concept of your res judicata and the concept of res sub judice. We will first see the similarities between the two of them. In both, we are talking about two separate proceedings, one which was instituted first and the second which was instituted after that. So, as to prevent multiplicity of proceedings, we have section number 10 which is sub judice and section number 11 which is res judicata. Okay. Sub judice is saying that both the proceedings are still being heard before the court of law. So, you put a stay to the second proceeding and let the first proceeding continue. Okay. Whereas in res judicata, the first suit has already been heard finally. So, that means in res judicata, a decree has already been issued in one of the previous suits. Whereas in res sub judice, there is no decree which has been given in either one of the suits. You are just putting a stay to one of the suits in res sub judice. In res judicata, you are preventing a person from being punished twice. So, since the decree is already passed in the first suit, the second suit is barred by res judicata. That is barred from being heard by the court of law. So, this we saw section number 11. Here decree is given, here decree is not given. Okay, and again the purpose of both of them is to prevent multiplicity of proceedings. So, this is where we had ended in the previous class. Now, I'd like to continue with this concept, I'd like to come back to this flowchart and continue from here. A few more concepts which I feel like is necessary for you all to know. Okay. Again, everything that I'm teaching you after this is all individual points. Okay, that you have to consider separately, may not be part of the flowchart. There is a concept known as joinder of parties. That means the rule is that if a person has a right and that right is violated, then he is entitled to a remedy. Ubi jus ibi remedium. Okay. But where there are multiple persons and all of their rights have been violated, then shouldn't all of them get access to the remedy and not just any one person? Similarly, the person violating the rights, what if it's not just one person but multiple persons? Then shouldn't all of them pay compensation for the harm that they've caused? Okay, so this is why we say that there can be multiple plaintiffs or multiple defendants. But sometimes the proper parties may not have been added, or the proper parties may not, or the wrong parties are there in the proceedings to the suit. Now I'll just give you an example, okay. Let's say that there is a person named Sam and there's another person named Prabhu, okay. Both of them are going before the court of law as joint plaintiffs, okay. Now let's say Prabhu passes away in an accident and he has two legal heirs, that is, let's just name them A and B for the time being. Now both of them are the plaintiffs, that means both of them went before the court of law and submitted a joint plaint before the court of law. But then when Prabhu passes away, after him who are his children? A and B. So that does it mean that after Prabhu's death the suit comes to an end? No. Does it mean that only Sam will continue being the plaintiff in this case? No. The legal heirs will now have to be added in. But now these two parties have to be added in as the proper parties. Like in the plaint itself, it must be amended so as to remove Prabhu's name and add A and B. Now, what if A and B didn't get added? Then I will say that is a non-joinder of parties. That means the persons who are required to be part of the suit are not part of the suit. So this is called as non-joinder of parties, and then you have to request the court to add them into the suit. So you amend the suit and you add their names as the plaintiffs to the suit. Okay. Now there may be a chance where, so this example is over, I am now moving on to the second example. Have you all heard of the concept known as privity of contract? That is, if, sorry, you were studying about it recently. Oh, okay, fine. So, alright, privity of contract says that if two people, say A and B, enter into a contract with each other, then only A and B can be parties to the contract. That they can only claim the rights out of the contract and they are the only ones liable under the contract. Now, person C has nothing to do with this contract over here, and C is who we call the stranger to the contract. Okay. So, let's say for example, A tells B, I'll sell you my goods provided that you sell it to a third party for 100 rupees and not any less than 100 rupees. Okay. So, what does B do? B sells to C for 110 rupees. So, what has B done over here? He has violated the agreement with A. Now, can A go before the court of law against C? The answer here is no, because only A and B were parties to a contract. If he wants, instead of going against C, he can go against B. Okay, but initially remember I had put A went against C. This is known as a misjoinder. That means a wrong person has been added into the suit, and that it has to be rectified to remove that party and put the correct person in. Also, this is just for an example point of view. Misjoinder, non-joinder is when there are more than one or more parties involved in the suit, and they may be added in or they may not be added in, either because they are required to be that part of the suit or they are there by mistake. Okay, so whenever we are referring to joinder of parties, we say that there can either be misjoinder of parties or there will be a non-joinder of parties. Misjoinder means, think of it like it's a mistake. That's a wrong person has been included in the suit. Non-joinder means the person who is required to be part of the suit is not there, and the court will ask that person to come and be part of the suit itself. Now, since we're talking about joinder of parties, this will come up for you as a question, not from an exam point of view, but from your own perspective, it will come up for you later on. What happens if there's more than, say, 100 plaintiffs, or 1,000 plaintiffs, or 10,000 plaintiffs? Like, say, for example, just shareholders of a company. If you take ITC or Reliance or something, there are not just thousands, few millions of people who are shareholders. So if all of them have one right against the company which was being violated, how do all of them end up going before the court of law? Because technically, all of them should approach the court of law for some kind of a remedy. And if, let's say that out of the 10,000 plaintiffs that are there, only 10 people go before the court of law, or let's say only 100 people go before the court of law, the court can give a remedy only to those 100 people. Because whosever name is there in the suit, they will only get the remedy. So what happens to the remaining 9,900 shareholders? So this is what we call as class action suits, okay, where there are too many plaintiffs, so too many defendants. What they will do is they will appoint one representative to appear before the court for all the proceedings of the court. And then whatever remedy the court gives will be applicable to all of them generally. So class action suits are looked at separately. Okay, we're not going to be looking at that over here. But at that time, you cannot come and say, no, there's a non-joinder of parties, because that has to be treated in a separate way. Non-joinder and misjoinder of parties comes when they'll say the parties will be affected whoever ends up being affected by the remedy given by the court, they are all the necessary parties. So what will the court do? Court will pass judgment. Court will grant a remedy to the not the defendants, the victims, and will ask the opposite party to pay up that kind of compensation. So whoever is expected to pay up will be the plaintiffs, and if all their names are not there, then there's been a non-joinder of parties. Or if unnecessary persons are being added as plaintiffs, there's a misjoinder. Same thing applies even for the remedy. Who and all are entitled to the remedy must be parties to the suit. Even if they are minors, if they are of unsound mind, etc., their legal guardians can represent them before the court of law. Ultimately, they should be a party to the suit. Okay. This is not a very big topic, but then the concept keeps coming up in smaller points as you go through the entire chapter. Okay. So this is one thing that we're looking at right now. Deposit of money in a court of law. Okay. Now, this topic that I'm entering into is a point where sometimes the parties to the suit will not turn up before the court of law. They will just choose to not turn up, or they will keep doing delay tactics, escape tactics, etc. So sometimes in some laws, the laws itself provide you have to deposit so much money with the court. But otherwise, the judges, like in the CPC itself, it provides a power to the judges to ask one of the parties to deposit certain money in the court. Now, what is this money? It can be relating to the suit itself. Now, just imagine that I need you all to attend class. Fine. But you all have no reason to stay in class. Let's say it's a Sunday, you all have gone out, had some nice biryani. You have no reason to come back to class here and sit and listen to someone talk about jurisprudence. Okay. Now, how do I ensure that you all come back to class? I take all of your phones and I keep it here. So then you have to come back. think of deposit of money in court as a similar tactic. It's like saying, what's to prevent one of the defendants from just selling his property in dispute and going? You can't catch him after that. You won't find him after that. If he moves to a different location, nobody will be able to find him. There are ways to get him to a court of law. But say, in a criminal matter, there are higher chances of sending the police and finding out that person. But then in civil matters, they will simply sell the property. So then how do you ensure their attendance in a court of law? You ask them to deposit money in the court, which can be quite a substantial amount. Like say the suit value is close to 12 crore rupees, but then you ask that person to deposit only 10,000 in court. He'll easily deposit the 10,000 and keep going on his way. So it won't be just 10,000 rupees, it will be a substantial value of the suit. Okay, and this is a power that is given to a court of law. Apart from deposit of money in a court of law, we are going to be studying about a concept which is known as production of documents Okay, before I go into this topic, I'm again going to give you a fresh example. Okay, this example relates to a property dispute. Property dispute being who is the true owner of the property. Let's say this is only the dispute before the court of law between two persons, A and B. But then A is the one who is residing in the whole property. A is the one residing in the whole property. B is not there in the country itself. Now A has the title deeds. What is a title deed? A title deed only? Yeah, like an agreement or ownership, exactly. It proves the ownership over your property. Because how else will you tell other people that I'm the owner of this property? You can't exactly write your name on a property and say, see, this is mine, right? So how do you get ownership? One way is through title deeds. Okay, and this is, what is a title deed? It should have proven that he bought it from someone, or he inherited it from someone, or it was gifted to him, something like that. Now this title deed is basically a document. Now B comes back into India and he is asking for his fair share in the property. Fine. But he comes back just to find out that A is telling him, no, this property is not yours. This property, let's assume that this document is a will that shows that the father is now transferred the entire property to the son. This can also be a title deed. A will is enough to show that you are the owner of this property. Now B approaches the court of law against A. Fine. Fair. B approaches the court of law and he calls A to the court saying that this is my fair share in property. I want the court to declare that I am also half the owner. But for this, what does B need? He needs evidence. Now, how is B claiming that he is the owner of the property, or at least half the property? Only this property could have belonged to the father. And after the father's death, through the will only, the property can come to both the sons, assuming. But a will can also say that I'm giving this entire property to my son A, or it can even say it's coming to both my sons in equal share, to A and B. But whatever it is, if you're going before the court of law, don't you need to provide the evidence? Okay. Now, who is holding the evidence? A is the one who has the title deeds. So, but it's B who's making the claim. The person making the claim has to provide the evidence. And what can B do over here? He can't do anything because he doesn't have the document with him. Then what he can do is, he can approach the court of law. The court will direct B to produce the document in the court. So this is what we call as production of documents. You have to produce the evidence, but what if it's not in your authority? What if it's not in your hands? Or what if this document was pledged to the bank and the bank has a copy of your title deeds? So when some other authority or person has the necessary documents to decide the dispute, the court can pass an order to produce those documents or produce that thing before the court of law. Okay, this is one power that is given to the court for procuring evidence, and we'll also call that as production of documents, or generally I will just say of evidence. Did you all understand the production of documents part? It's simply to direct someone else to bring the necessary evidence before the court. Now, what is this concept of search and seizure? Producing the documents is like you're asking nicely. You're telling the other party, I request you to come and produce those documents before the court of law. Search and seizure is happening against your will. Okay, tell me this. If I enter into your property, say your homes, I enter into your home, search all your cupboards, search everything, take necessary documents and leave. Will you file a case of trespass against me? So it's not legal. It's not legal for anyone to come into your house and violate your privacy. So how can a policeman or some judicial officer just turn up in your house and do search and seizure? It's not generally allowed. But a court of law, that is a civil court, has the power to to search as well as seize things from your house. This is a compulsive action. That means it's against your will. The police can enter into your property, search. It must be search and seizure. If it's only search, then they will only go search the property and note down whatever they found. If it's search and seizure only, they can actually confiscate. And both these powers vest with the civil court. Okay. Fine. So this was just one of topics here and there that came up. There are some more. When we're going through the textbook that time, we'll see the other topics. Now we stopped at the decree in the previous class, in that flow chart. After the decree, there are certain steps which you can take. Anyone wants to take a guess what those steps are? Exactly. You can go on appeal. Okay, and this appeal is by itself is a whole topic. We have the concept of first appeal, and second appeal. What is first appeal? The very first authority that you're going on appeal to. Second appeal? The second authority that you're going on appeal to. Is appeal a fundamental, like a right? Can you always go on appeal no matter what? Just because I said fundamental rights, you all are saying fundamental rights. So, okay. You all have all heard of the concept of appeal. My question to you is, can you go on appeal regardless? No. Yes. Who else saying yes, no? Yes. Means, should the law allow you to go on appeal and only then you can go, or regardless of what the law says, you can always go on appeal to the higher courts? You're saying to get a remedy, you don't have to go to the court of law, you can get it done by yourself. Okay, that comes a little bit later on. We'll see that later, but fine. Only if the law allows you to go on appeal can you actually go on appeal. It is not an inherent right. That means you don't just go to the civil court and then you have a right to go to the high court, or you don't just have a right to go to the Supreme Court. The law has to allow you to go on appeal to the higher courts. Okay. But before we go into this concept of first appeal, second appeal and all of that, there's just something that you all are required to know. Okay. Please note this bit down. There's something known as a question of fact and a question of law. Okay. A question of fact. Let's say there's a case of trespass. So how will you, what did I say should be there in the plaint? All the facts, the cause of action. So that means you must say that Akash is my neighbor. He lives in the property situated next to mine. You have to mention the address. Then as on 5:30 a.m. on this particular date, Akash was seen entering my property as is evidenced by the camera. So these are facts. And then you're claiming that he trespassed into the property, stole this and then left. Now this is a fact that Akash trespassed into the property at 5:30 a.m. Now Akash can come in his defense and say, I was not even in India on this date, let alone at 5:30 a.m. So that person that you see in the camera is not me. This could be his defense. Now what are they disputing over here? A fact. A fact that one person entered into the property. Okay. So these questions of fact, that is determining the evidence part of it, and facts will only be determined at the lower court level. It will never be taken into consideration at a high court and a Supreme Court level. Okay. High Court and Supreme Court mostly only looks at questions of law. Like, let me some examples of question of law is whether Aadhaar is constitutional or not, whether fundamental rights can be amended, whether the right of privacy is being abused. This is all an interpretation of our existing laws. Only questions of law can can be heard before the High Court and the Supreme Court. Okay, so I'll give you an example. Not an example, it's a real case. It's known as the Shabano case. Okay, you all have heard of the triple talaq concept in Islamic law? Okay, one person knows, the others don't. It's a thing of divorce. Hindus don't look at divorce as a concept, even though we have a law on it. Christians also don't look at the concept of divorce, even though it is accepted for them to one point. Muslims look at marriage as a contract, and a contract can be broken, and hence divorce is also very much valid. Now, there's this concept known as talaq, 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 triple talaq. That means if a man simply says talaq 3 times, then he instantly divorces his wife, even if he is not in the same room as her, if he is not even looking at her. He can be in a completely different country, say talaq, talaq, talaq on spot, and then he has divorced his wife. Exactly, it's ridiculous. Okay, but this is what had happened to this lady called Shabano. And finally, Shabano turned out to be around Shabano Begum. She was 65 years old when her husband divorced her. She has 3 children. And Islamic law has very weird concepts of maintenance, etc. And ultimately, it was she's the victim, and she's the one who's at a disadvantage. Because first of all, a lot of Muslim women are not allowed to go to work. They're not allowed to meet people outside. At the age of 65, if you divorce her and give her a pitiful maintenance, how is she going to survive out there in the world? So this is what she approached the courts for. She approached the criminal court, the lower court, for this. But the lower courts could not really do anything because Islamic law is slightly different. Finally, what she did was she approached the High Court and she challenged the very concept of talaq, 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 talaq. Because she went and challenged that, saying that this concept of saying talaq immediately 3 times is actually not a recognized principle in Muslim law. That talaq should be said once, say today, 1 month later the second one, and then another month later the third talaq. So the talaq proceeds over 3 full months. Okay, and then only a divorce can actually take place. So what did she go and challenge? She challenged the very concept of the divorce proceedings, which is recognized by law. That was a question of law which was accepted by the Supreme Court and the High Court. So are you all understanding what is the difference between question of law and question of fact? Okay, and like this example, you'll have many things challenging the constitutional validity of a law, of a provision, of the interpretation of a particular court. Only these can go on appeal. Okay, and normally when you go on first appeal, say you're going from the lower court, you'll go on appeal to the High Court. Okay, you need a certificate from the lower court to even go on appeal to the High Court, because the lower court has to certify that yes, there is a question of law over here, and that the higher court has the ability to look into this matter. But if there is no question of law, then you can't end up going on appeal to a higher court. And the same thing applies even for Supreme Court. Are you clear on this concept? There is only one situation where you can approach directly from the lower court to the Supreme Court. It's what we call as an SLP, Special Leave Petition. They call it as an SLP petition, where you directly approach the Supreme Court. There are certain factors, conditions why this should be allowed. In short, it's like saying you have special leave to skip the High Court and go directly to the Supreme Court in this matter. Fine? Okay. Now, one thing that I've written in red over here, in the Supreme Court and the High Court, no new evidence will be accepted. That means whatever evidence was given at the lower court level itself is the same evidence which will be carried forward to the High Court and the Supreme Court. Now, this is not a hard and fast rule. If the court believes that there is a necessary evidence to be granted, then they can accept new evidence. Okay, but generally as a principle, the court will not accept the new evidence in the higher court and the appellate court levels. Please just remember this point as a concept. Question of law, question of facts, the principle of admitting evidence, and the concept of a special leave petition. Right? Now, once a decree is given, we've seen that appeal is only one kind of a remedy against the decision of a decree. Also, one thing, can a person go on appeal even before the decree is given? Anyone saying yes? No. So, everyone saying no. Only once a copy of the decree has been handed to you can you go on appeal. Okay. Now, didn't I say that a decree and an order are similar, are actually the same actually, that an order is temporary and a decree is final. Okay. So, if I can go on appeal from a decree, does it automatically stand to say that I can go on appeal from an order? Yes? Okay, I'll repeat it again. If I can go on appeal from a decree, then isn't it logical that I can also go on appeal from an order? Yes? Ideally, the answer is yes, because a decree and order are the same. But appeals against orders are not allowed. Because remember, I told you when an order is given between the proceedings. So, let's just say that A goes to court of law against B, submits the plaint. But then the court also issues an order. Let's say a court issues an order of injunction immediately in favor of A. So, in favor of A and against B. Now, what does B do? B is unhappy with the order, so he'll go on appeal from this order against it. Then what can the higher court do? The higher court will say no, remove the order, and that will take its own proceedings. But remember, finally these proceedings are still happening before the court of law. So you'll be creating a branch of legal proceedings indirectly if you keep allowing appeals from orders. Idea is that an order is just like a decree and it can be appealed from. But because it will cause more delay, more technicalities in proceedings, they're saying that there is no appeal from an order. And there are only four or five exceptions for this, which we will study about later. So please remember, there is no appeals from orders with the exception of a very few criteria. But otherwise, you can only go on appeal from a decree. Okay. Now, appeals is not the only remedy that you have. There are three other different types of remedies apart from an appeal which a person has. And they are known as reference to High Court, review, and revision. Hello? Hello? Okay, so we have appeal and the 3 R's. If they ask what remedy is available to the plaintiff or the defendant post the decree, it's not just appeal which is the remedy, but reference, review, revision. What is reference to the High Court? Reference to the High Court is like it's like asking a senior for help. So if your confused about a certain interpretation of the law, or if you are not sure about how this law has to be applied before the parties, then what the lower court will do is they'll write a reference to the High Court. The High Court will give their opinion within a period of 60 days, 30 to 60 days if I'm not wrong, and the opinion that they give can be used as an interpretation before this lower court. Please understand that this is not an appeal process. You're not getting the decree and then going to the High Court. While the proceedings are going on in the lower court itself, the judges themselves are asking for an opinion from the High Court, and that's what they call as reference to High Court. It's simply like asking your seniors for help. Okay, it happens sometimes in the court of law itself. There is no requirement for them to apply the exact same. Remember, it's only an opinion. It's not like if the High Court gives that interpretation, it has to be followed. It's rather only an opinion which can also be applied before the proceedings. Okay. The next one is, I'll write this, ask senior for help. Just for you all to remember this, okay? We'll look at the proceedings in detail later. Review is you're going back to the same court. You're going back to the same judge and you're telling the judge you made a mistake or you made an error and that you have to rectify it. Anyone ever tried going back to your teachers and saying, no, you corrected my paper wrong? You try that and see what happens to you. Okay? So review is not something that is so easily accepted. Review is you're going back to the exact same judge and you're telling the judge you made a mistake, that you made a really grave error, that if you don't review the same judgment again, then I will be inconvenienced. And this power of review is entirely the judge's to accept, which means he can just reject your application from the get-go. He can just say, I'm sorry, I'm not going to listen to your application, and there's nothing to stop him. But if he does feel like he made an error, a mistake, or a really big mistake basically, then the review process will be allowed. Okay, this is in very rare case scenarios. Almost at no point has a review been accepted by the court of law, because it's like you're going and telling the judge everything that you did was wrong over here. And mostly it will be the parties who have against whom the decision has been given. So rather than going on appeal, you're choosing to go back and harass the court again. Okay. And finally, revision. Now, revision is a slightly different concept. Revision is the High Court is reviewing a matter. So to explain revision, just look at this. There is a court known as the small causes court. I had mentioned it in passing in the previous class, where all your check bounce cases, matters under say 10,000 rupees, monthly rental disputes, very small cases. These are the matters which will be tried before a small causes court. Okay, this so that it's faster. It can be decided faster and done also. Now, if you have to go on appeal from the small causes court, you don't go to the High Court. You go to the district civil courts. Then above the civil court only you have your High Court and your Supreme Court. Okay. Now what it says is all matters that are heard before the small causes court cannot ever have a right of second appeal. Which means what? Which means that this appeal will be allowed. But everything beyond this is not allowed. Second appeal is not allowed, and definitely third appeal is not allowed. Why is this the case? Is that, first of all, the matter is so small. It can be as low as 5,000 rupees, 10,000 rupees, etc. Your court fee for the High Court itself will exceed the subject matter of your suit. So then you're paying higher court fees than the remedy that you're going to get. So for that reason, they're saying that for small causes court, you are only allowed first appeal, and that first appeal also will be in certain rare case scenarios. Okay. Now, can I say that High Court has no oversight in this matter? Supreme Court has no oversight in this matter. But is there a chance that either of these courts can create an error or a mistake? They are courts, right? They are capable of making some error or mistake. Now, ideally, you should have been able to go to the High Court to get the error rectified or some kind of a remedy. But that's what they've said, no, that you can't go before the High Court itself. So there will be many situations like this example that I just told you, where sometimes the law itself will say there is no right of appeal. You cannot go on appeal, or there is no right of appeal to a High Court. In that situation, this remedy of revision exists, which means even though you don't go before the High Court, you can request the High Court to pick out this matter and look into this matter, because you feel like there's some procedural mistake or there's some issue with the proceedings which took place, and that you require the High Court's oversight into the matter. Okay. So, I'm just repeating myself again, these are certain remedies that exist under CPC. Can you appeal against a decree? The answer is yes. But for that, the law must clearly specify and state that you have the right of appeal. Can you appeal against an order? The answer is no. There are only four or five exceptions to that rule. Apart from appeal, that is first appeal and second appeal, you have reference, review and revision. Reference is like asking for a clarification from High Court. Your review is you're going back to the same court for a revision in the judgment or a change of the judgment. This is entirely the power of that judge itself to receive your matter. He can choose to disregard your petition then and there itself. And then revision is a High Court which actually does not have any jurisdiction is taking the matter for review because they believe there's some procedural irregularity or a mistake which is taking place. It only applies to those suits which do not have any right to go to the High Court for a remedy. That time you can appear before this court for revision. Okay. Are you all following so far? So after decree, we've seen res judicata, sub judice, deposit of money in court, production of documents, search and seizure, orders, appeals, reference, review, revision. Okay. The last two concepts that are important from a general point of view is something known as summary suits and inherent powers of a civil court. These are the last two topics that we look at before we go into our portions itself, like notes. What are summary suits? Summary suits are basically those kind of suits where first the statute has decided The law itself is saying that this suit has to be decided summarily. Okay. So basically, summary suits is a certain type of a procedure. Okay. What is it is that it is a faster way to dispose suits. In this, the defendant does not have a right to defend himself. The defendant does not have a right to defend himself. The exception to this rule is that the defendant within 10 days, the defendant if the defendant wants to argue, then he is being given a period of 10 days time within which he needs to ask permission and defend himself. Okay. This is the gist of your summary suits. We'll also be looking at things like which courts can hear it. Almost all civil courts has the power to try summarily. But mostly you will see all these small causes court will try summary suits only. Now, what is this concept where defendant does not have a right to defend himself? Isn't this a violation of principles of natural justice? So, how can this be allowed before a court of law? Please remember that if the statute is mentioning that it can be tried summarily, it's because we already know that the defendant is guilty and that there is no point giving him a chance to be heard, defend himself, just to find out that he's still guilty. Okay, so instead of going ahead with that procedure, we are just holding him guilty. Which situations can this be? Check bounce. I've given you a check that says 1 lakh rupees on it and you've gone and deposited the check. What has happened? It has bounced. Now, I'm the one who gave you the check, right? So, when it bounced, I'm automatically guilty. Unless I can prove that I never gave that check or that check was forged by the plaintiff, by y'all. So, if I need to go and defend myself, I must do it within 10 days time. But otherwise, it's a check bounce case. I am automatically guilty. What is the need to give me a chance to be heard? Second one, what if, okay, this is a criminal provision, okay, but let's say that the police come search your house just to find the stolen property that they're searching for. Stolen property found in your house automatically makes you the thief. So, do we have to give you a chance to be heard, to say, no, I don't know where this came from? No. They will automatically take this as a guilt. So, there are some situations where the statute itself will say this has to be tried summarily. And also the level of punishment that is granted, right, will be a very low punishment. It's not a very high punishment. Whether you see it in civil suits or in criminal cases, the imprisonment in criminal cases will not exceed, I think, 3 months if I'm not wrong. And for civil also, the penalty will be very, very low. The fine to be paid will be very low. So, summary procedure is just a shortcut form of a normal suit, but where we know that the defendant is already guilty. Okay. So, this is one concept known as summary trial or summary procedure. And the last one is what I told you as the inherent power of civil court. It's like an emergency power. The code provides for a very extensive list of procedures to be followed while carrying out anything in a court of law. Okay, but say for example the CPC is silent on procedure, and in the interest of justice, the civil courts can exercise this power known as the inherent power of the civil court, where they can depart from first of all, there is no procedure. They can execute whatever is necessary for achieving justice or for achieving the objective of the court. So what is an emergency power? There is no law, there is no rule, nobody has no idea what to do, but the courts need to also provide and impart justice to the people. That time they can implement this inherent power. It's like an arbitrary power where the court can say, okay, evidence need not be submitted, or a certain rule need not be followed in this matter. Something like that. It's a emergency power that is granted to the court. And it was seen in one very important case, which we will see later. One case law where the court came down and determined, see, these are what constitutes the inherent power of the civil courts. Fine. So guys, whatever we've studied so far is a gist of your entire CPC. Give or take a few topics here and there which we will cover. This is only everything that's going to be covered in your CPC. So if you all had read the important stages of proceedings in a suit, you will see many definitions and then the actual procedure inside and the rules relating to the same. So if you're going to be looking at appeal, reference, review, revision, orders, exceptions to orders, these are all what you're going to be studying under CPC. Okay.